All right, so I've been told that we should start now. So hello, everyone. My name is Susan Cote-Freeman, and I'm the chair and president of Transparency International Canada. And it's my pleasure to welcome you to our week of dialogue. Mesdames et messieurs, je suis ravie de vous accueillir à la semaine de dialogue de Transparency International. Normally we'd be meeting in person, but because of the pandemic, obviously we've had to rethink, like so many organizations, we've had to rethink the format of our flagship event. So we hope this works out well, and I hope you'll bear with us if there are any technical glitches. We're all novices at this, so but hopefully everything should work smoothly. The silver lining is that we normally get about 100 people at our in-person events, and we've had more than 300 people registered for this week of lunchtime webinars. So welcome everyone. Pour ceux d'entre vous qui ne connaissent pas Transparency International, ou TI comme on l'appelle, est une ONG qui mène la lutte contre la corruption à travers le monde. TI a vu le jour en 1996 et son secrétariat est situé à Berlin. Et nous sommes présents dans plus de 100 pays, dont le Canada. TI Canada is the Canadian chapter of Transparency International. We have a small head office in Toronto, and our board and supporters can be found from all over the country. And for more information on our areas of work and our reports, I really encourage you to look at our website, transparencycanada.ca. I also encourage you to become members and supporters, because that support is really essential for us to carry out our mission. Allow me to thank our current supporters for this event. Our platinum supporter, Export Development Canada, our gold supporters, BLG, Blake's, Banque Nationale, Deloitte Canada, Dentons Canada, Sky Power Global, and Siemens. And finally, our silver supporters, the Association of Canadian Financial Officers, ALESA, Kinross Gold, KPMG Canada, Thales Canada, and Groupe Vidocq. So this week, we're going to look at what's wrong with Canada and try to understand whether Canada is taking anti-corruption seriously. And this topic came in the process of speaking to supporters and experts who we know at TI Canada, because we were preparing our next strategy. And one of the common frustrations that came up when we were speaking to people is that Canada probably should be doing much more to counter corruption. So we thought we'd devote this week of webinars to this issue. And we're going to look at different aspects of this question. We're going to be looking at our institutions, at our laws and regulations. We're going to draw some lessons from organizations and companies and how they address the problem. We're going to look at experiences from abroad. And finally, on Friday, we're going to try to tie it all up in a bow and share some conclusions with you. But to start things off, we're going to take a sort of overhead view and look at anti-corruption in Canada from a high-level perspective. And we're doing this with an exceptional panel. Just a couple of housekeeping items before I introduce our moderator for today. You will all see at the bottom of your screens the chat function and the Q&A. Now, we want this to be a dialogue. It's a little harder with our format today, but we really encourage you to write in comments in the comments section if you want to do that. Keep it civil, please. And you can address questions to the panel through the Q&A channel. So please respect those rules while engaging with the panelists and the moderator. Now, I'm very pleased to introduce our moderator for today's panel. I think she actually needs no introduction. She's a public figure, Diana Swain. She's an award-winning investigative journalist with CBC News, who's been working in Canada for more than 30 years. She's currently the senior investigative editor for CBC News, overseeing several investigative teams, including reporters, producers, researchers, and data journalists. Diana has reported hundreds of stories, including many that are focused on tax evasions and money laundering, topics that are very, very important for TI Canada. She's a senior fellow at the Glendon School of International and Public Affairs at York University in Toronto. And she is the recipient of an honorary doctorate from the British Columbia Institute of Technology and an honorary degree from Humber College in Toronto. So I can't think of anybody who's better equipped to moderate our panel today, Diana. So welcome, and the floor is all yours.
Thank you, and hello everyone. Thanks for giving us your time today. I should say good morning, good afternoon, or good evening, because the one thing that is good about this new way of communicating and connecting with people is that we can do that across time zones. And Drago is probably the one who's the furthest away from the rest of us, so thanks for joining us. And welcome everyone to this opening session of this year's conference. We've got about the next hour and a half to discuss a question that is actually central to Canada's identity, both at home and abroad. And that is, when we identify corruption within our borders or involving Canadians or Canadian corporations outside our borders, behaving outside the law, do we use all of the means at our disposal to hold those individuals and or companies to account? And if not, why not? What is it that stands in our way? Is it our laws, our reach, or our will? We have three panelists today who are going to talk through that question and also the central theme of today's session. So let me begin by introducing our panelists. They're all going to make some opening remarks. I have a few questions to pass at them. It's occupational hazard. And then of course, I'll be checking the Q&A marker to see if you have questions that I can put to the panel as well. So in no particular order, but I'm pleased to introduce all three of them. First, retired Chief Justice of Canada, the Right Honourable Beverley McLachlin. Before retiring from the bench in 2017, she was Chief Justice for 17 years. That's the longest term for any Chief Justice in Canada. She was the first and only woman to hold that role. Presently, Ms. McLachlin works as an arbitrator and mediator in Canada and abroad, calling on her 35 years of legal experience, deciding a wide range of business law and public law disputes. Ms. McLachlin also sits as a Justice of Singapore's International Commercial Court and the Hong Kong Final Court of Appeal. She's a companion of the Order of Canada, this country's highest public honor. Thank you. Drago is currently the chair of the OECD Working Group on Bribery and International Business Transactions, and co-chair of MENA, the OECD Business Integrity Network, and member of the Selection Commission for the head of the Special Anti-Corruption Prosecution Service in Ukraine. He's also been a member of the International Anti-Corruption Advisory Board in Ukraine and a co-chair and member of the Defense Corruption Monitoring Committee in that country. Between 2011 and 2015, he was the International Commissioner and chair of the Joint Independent Anti-Corruption Monitoring and Evaluation Committee in Afghanistan. Between 2003 and 2011, he was the chairman of the Council of Europe's Group of States Against Corruption. Hello, Drago. And Lida Preyma is joining us as well today as our third panelist. She has over 22 years of experience in Canadian capital markets. Lida is currently the Director of Global AML, Risk Management, and AML RO Designate at BMO Capital Markets. She's led the development of the site visit program for high-risk clients, advises on global policy developments, and has represented BMO since 2014 on 3 B20 task forces, providing policy recommendations to the G20 anti-corruption, trade, and investment and financing growth. In her previous role as Director of Global AML Compliance, she was responsible for regulatory compliance management, issue management, inherent risk assessments, and testing. So as I mentioned, the session begins this week with an assumption, as you'll have seen from the opening part of this plenary. What is wrong with Canada assumes that there is something wrong, that we're not getting it right. So the first question to our panelists is, do they share that view? So all of us have spoken beforehand and we're comfortable using our first names just to have a casual conversation. So Beverley, let me begin with you. A couple of minutes for you to address the notion of whether we are getting it wrong.
Well, thank you very much, Diana, and thank you everyone for being online to share this important discussion with us. My impression from what I read, and certainly international assessments like the OECD, is that we are not getting good marks internationally on our efforts to fight corruption on the international level. The OECD report of 2012 said that Canada was the worst G7 nation in fighting bribery of all the G7 nations. And another report in 2020 just come out, used language like efforts that were shockingly low. And actually we're in good company in being low, because that report, which was picked up in the National Post, and some of you may have read it a week ago or so, that report said that only 4 countries really actively enforce against foreign bribery: the United States, the United Kingdom, Switzerland, and Israel. So I would like to be in the top 4, and we are definitely not there. So that report card speaks for itself. Where are we falling down? There are at least 4 ways of fighting or ensuring compliance with OECD standards and anti-bribery and anti-corruption: prosecution, freezing and seizure like the Magnitsky Act, remediation, think SNC-Lavalin, alternative routes cooperative to improving situations within a country, and finally compliance culture. But we are really falling down, I think, in the number of prosecutions, successful prosecutions, which are very, very few. I think we've had, I couldn't get the exact number, but 7, 8, say, in over a number of years. And the United States in 1 year had 112. So, you know, we just don't get out there and get the prosecutions. I can talk about why that is, what's wrong with the law, perhaps. And the other area, we're not really effectively using remediation. We have a law that was brought into force a few years ago, but we all know the story about SNC-Lavalin, and I can talk more about that too, and what we might be doing to try to improve that situation. But basically, I think that's my overview. We are not doing as well as we should.
Thank you. Lida, can I ask you to go next?
Sure, thank you very much. I'd like to thank TI for inviting me to speak today. And of course, I must start off the talk with saying that all views are my own and not the views of Bank of Montreal, but super happy to participate in the discussion. I think that the second part, are we taking this seriously enough? I think it's a two-parter, if you will. Financial institutions are taking this seriously. LexisNexis recently came out with results of a market survey of financial institutions in Canada and the US. And they found that in Canada, mid to large size banks spend an average annually of $25 million a year on compliance. And asset managers also spend 18 million. So if you take 5 from each category, if we look at 10 institutions, that's $215 million spent annually on compliance. So you're not going to spend that kind of money if you're not serious about compliance. Where I think we have areas for improvement for Canada is the pace at which we move and the siloed approach that we've been taking to trying to solve a complex problem. So if I give an example, in 2016, the Financial Action Task Force provided its mutual evaluation report, where we had good marks in some areas, but obvious improvements needed in other areas. There were 10 policy actions that were provided, and it took 3 years for the government to pass legislation in order to move forward. And it's going to take another 2.5 years for the implementation, the full implementation of those regulations. So we're looking at over 5 years to respond to the mutual evaluation. Now, internationally, everybody looks at what is the information available from public sources. And for Canada, what's available? Our 2016 mutual evaluation. So if I give you that same time period, in comparison, the EU put forward its 4th anti-money laundering directive and also its 5th anti-money laundering directive, and now it's on to its 6th. And while we have been talking about a corporate registry for years, the 4th money laundering directive had corporate registries for all 27 member countries, and the 5th one made it public. So the pace at which we move means that we're continuously playing catch up. So rather than being policy makers, we've become policy takers. And we have to then follow and catch up to what everybody else is doing. And when I say we were policy makers, it was our G20 Toronto Summit back in 2010 that the G20 formed the Anti-Corruption Working Group, which provided recommendations to leaders and also to member countries. We now have to take a look at what everybody else is doing in order to catch up. We're also working in a siloed approach. So we have regulated entity guidelines. So OSFI's got its 2nd regulatory package, which is sweeping, so that does take time to implement. You've got the governments working on the corporate registry at a slow pace. And then you've got law enforcement. And as Beverley mentioned, you know, there have been very few specific money laundering convictions. And that's because it's usually attached to a predicate offense. And so sometimes pleaded away. But for example, in the US, the FBI and the US Attorney's Office in the last year have both created dedicated units specifically for money laundering. So until we take a more holistic approach to the complex problem and work in collaboration where we take all viewpoints and come up with solutions, we're gonna still playing catch up and be middle of the road.
Thank you for that. And now for the view from outside of our borders. Drago, could you tell us how we look from outside?
Well, hi Diana, and let's say thank you TTI Canada for inviting me to this event. I have to say that from the outside, Canada, well, it's still not the best country in the world in fighting corruption, but I have to say that it's improving. Beverley mentioned our report back in 2012, which was really a bad one. It was also adopted in under very, very, let's say, strange circumstances. I was not the chair of the working group on bribery there yet, but I've been told that this was really a very painful exercise. So from then on, Canada is moving into the right direction, but it is moving extremely slow. I have to say that in the last years, what we observed is the change of the attitude. What was obvious before that, it was, let's say, that the major goal of Canadian participation in the working group was the, let's say, protection of Canada's image. Now things have changed. Now Canada is really engaging in many different areas. I could see this in the group. I can see this following the, let's say, the developments of certain areas. Let's say, you don't have many countries where governments would organize public consultations on how to increase the liability of legal persons toolkit, as it happened in 2017. Or this year, there was a public consultation on beneficiary owners, transparency. Once we heard the presentation of the colleagues from the RCMP and the group on their anti-corruption educational programs, and it was so good that we invited them back to give us a broader picture. So, and I can see from the, let's say, from the debates from the side of Canadian representatives in the group that basically they are taking the issue of foreign bribery, and because we are dealing with foreign bribery only, very seriously. So this is the positive part. What is not so good is what Beverley also mentioned, that Canada is, let's say, lagging far behind in the area of concrete enforcement of the convention. So let's say in the last 4 years, from 2016 to 19, according to TI Exporting Corruption report, which just came out, Canada has only had 2 investigations on potential foreign bribery cases. 1 trial has been opened and 4 cases have been closed with sanctions. So altogether, that makes 7 cases. Now, in the same time, let's say your southern neighbors were dealing with hundreds of foreign bribery cases. And this is the biggest problem which we have with Canada now. It looks that Canada has a decent legal framework in place. I don't have any doubts in Canadian, let's say, institutional framework, because I'm meeting representatives of different agencies in the group, and they're all very good professionals, devoted and really willing to do the job. But we don't have the cases, or basically say Canada doesn't have the cases. And I think this is the biggest problem right now. We had to push a lot in the past for, let's say, legislative changes and so on. And really, as Lida has said, many years have been needed to the changes have been made. And what we do now is basically we're really pushing hard to make Canada engage a bit more in this law enforcement area. It's pity to see that Canada is one of the G7 countries in the world, not only economically important, but also important for many other reasons too, is in the second worst group when you speak about the enforcement of the convention, of the OECD convention. So here, I think Canada is lagging far behind its objective capabilities, and here's the chance for improvement, and we will be pushing hard together.
Thank you, all three of you, for those opening remarks. I think that gives us a number of things that we can touch on to begin the conversation. Beverley, I'm sure there's a tremendous amount of interest among those who are listening in your thoughts around SNC-Lavalin. But again, also against what Drago has just said, where when you measure us against the United States, for instance, we have perhaps a handful of cases started, some closed, some proceeded, against hundreds in the United States. What is the barrier to pursuing these things in Canada? And is SNC an example of Canada getting it right or getting it wrong?
Okay, I think there's two different questions there. With SNC, we're talking about a very important method of enforcement called remediation, which is its own thing. The more basic method of enforcement, and the one Drago was just referring to, is prosecution. And we have legislation in place. It's called the Corrupt Foreign Public Offences Act, CFPOA, and we have from time to time amended it. The problem is we don't get many prosecutions under it. And so this question is the first question I asked when I was preparing for this panel. Why are we not getting many prosecutions? And I mean, just a handful over many, many years. There have been suggestions of several things that make it difficult to prosecute in Canada. One is that our law has a very high intentional or mens rea requirement. You have to establish that senior people in the company were either knowingly or recklessly participating in, for example, the bribery. And in practice, I'm told that this is so difficult to prove in a corporate culture situation, and that people say anecdotally, you almost have to have an admission from somebody, which is very rare, doesn't happen, to make a prosecution work. So we have this dedicated unit in the RCMP that works on these things, but I think it must be that in many cases, perhaps the prosecutorial people in charge say, we're not going to have a very good chance of proving this and getting the conviction. So I think we might want to look at the standards. We've also have a tie back to somebody in Canada, and some legislation in other countries doesn't do that. That makes another hurdle. And we have a federal, provincial, here it comes again, divide. Domestic corruption is basically the province's responsibility to prosecute. International, if there's an international aspect, is the federal. And I'm told by people who know this area much better than I, that that can also pose problems. That is, I think, some of the difficulties we're facing on the prosecution side, where we see our neighbors prosecuting many, many cases, and we're not able to. So it seems to me we need to, I don't have the answers, but I think we need in Canada to take a really good look at our legislation and see if we could find examples in the United States, in Germany, in France, and so on, UK, of different ways to approach some of these prosecutorial issues. The other area you mentioned is the remediation agreements, and we did pass a law rather late in the game a few years ago on this. It has not been much used, and I don't have anything specific to say about SNC-Lavalin, but I think that it has raised questions of prosecutorial independence. Now, in the end, that independence was exercised, but perhaps there's a sense that nobody wants to go the remedial route anymore. I don't know, but we need to ask ourselves that question. Can we use this, which is used very aggressively in other countries, given the difficulty of prosecution? You can't get admissions. What you're dependent on are whistleblowers, and the United States gives big money to whistleblowers. I read about 114 million went to a whistleblower under the SEC not too long ago. And you have these remediation agreements whereby a company comes forward and says, we did this, we're sorry, we're going to pay a bunch of money and fines, and we're going to go through a process of revising our internal procedures. Those seem to work quite well, and I think we need to find ways to make them work better in Canada.
Drago, just before we move off SNC-Lavalin, because there are a number of questions coming in already in different topics, one of the things that was presented to Canadians, and those who don't follow this as closely as many of you do, is that in the context of SNC-Lavalin, the government was being argued to a point, if you proceed with prosecution, the damage goes beyond SNC-Lavalin. It will affect the 9,000 people that are directly employed by SNC-Lavalin. It will have spin-off effects on other infrastructure projects, other companies, that the impact would far outstrip whatever penalty was meant for the company. And yet your organization says specifically that countries should not be influenced, quote, by considerations of national economic interest when deciding how to proceed with penalties. So how should countries like Canada balance that?
Well, this is not what we say in the group. This is what the convention says, the convention to which Canada has adhered to. So it is the famous Article 5, which is it's the unique article of our convention, because no other anti-corruption convention in the world has it. While we reacted last year was not because that we would say, well, this remediation agreement is out of the question for SNC, but because there was, now it can state it positively, definitely, that it was political interference in the prosecutorial independence when making a decision. Should there be a trial or this remediation agreement process? This is what made us reacting. We always leave to the, let's say, prosecutorial or judicial authorities of the country to decide which way they will use. And I can tell, let's say, in the world, the overwhelming majority of cases of international bribery involving companies is dealt with by, we call them leniency agreements. Well, lately we call them non-trial resolutions, but basically this is what you in Canada call a remediation agreement. So it is more and more used. Companies go less and less go to trial because for different reasons they think that this path is better for them, and also the prosecutions obviously also think the same. The reason why we have this Article 5 in the convention, we're not only saying that national economic interest, but we're also saying, let's say, that foreign diplomatic relations and or the identity of natural legal persons involved should not influence the procedures and sanctioning in those cases is very simple. We are a group of 44 with very different legal frameworks, different institutional frameworks, different level of democracy, different level of rule of law. And I think basically this Article 5 is the essence of any fight against corruption. The big, let's not call them big guys. Let's say the presidents, the prime ministers, the untouchables. Who are untouchables are untouchable because they are what they are because of their position, because of their name, or because they can always invoke that they are doing bad things because of national economic interest or foreign diplomatic relations. So we wanted to prevent that. We wanted really that when prosecutions and judiciary would make a decision, they would make a decision on the merit of the case only. And this is why we reacted. And I have to say, I was following a very civilized and polite debate with Canadian representatives when we were discussing the issue, although it was not always, let's say, very friendly. You can imagine that, it was not, Canada did not react very happily when they realized that they will get the public statement. We realized basically that the system is functioning. The system in the sense that it is protecting the prosecutorial independence. We did not even analyze what happened later on. Of course, we know. We will deal with that when Canada will be examined next, but that will be a regular examination, which has now been postponed, I think, up to 2023. So the system is functioning. The system is defending the prosecutorial independence. And this is, for the moment, the most important thing for us.
Thank you for that. Some of the questions that are starting to come in now are moving our conversation from the notion of corruption into money laundering. And so there's a question for you, Lida. You referred in your opening remarks to the amount spent by banks on compliance. But the recent case against Citibank in the US, which resulted in a $400 million fine, and I fear I'm going to have my Mike Pence moment with this fly any moment, was despite the fact that Citibank had huge compliance departments and showed that compliance is often more about window dressing than actual compliance. So are Canadian banks engaged in the real thing or in the window dressing?
Well, I have to emphatically say we are not engaged in window dressing. We are definitely engaged in the real thing. And listen, no bank wants to have illicit money flowing through them, but we can only do so much. Governments and law enforcement have downloaded responsibilities onto the financial institutions, and we have risk-based programs. We are trying to comply with every regulation that we have out there. Let me actually give you an example of, it's going to touch back on the corruption part of it, but really part of it is the cost of compliance, which I mentioned earlier at 25 million a year over the last year. Let me tell you a small case that came up last week, and I say small with some jest, and it is involving Goldman Sachs. So this is the cost of non-compliance that financial institutions are very aware of. So last week, they entered into a deferred prosecution agreement with the Department of Justice. They admitted that they broke US corruption laws, and this is in connection with the 1MDB scandal. So it's the Malaysian investment fund. And so they've had to pay over $5 billion in financial penalties. It's the largest US fine at $2.9 billion to the Justice Department. They've cut bonuses. They've clawed back pay from previous executives. They have 2 bankers that have been criminally charged. Now, as you're going forward and as financial institutions go forward, this provides, for what Beverley was saying, if we look to what other countries are doing, this can now provide an example. Financial institutions now have this as an example to look to. So Goldman Sachs made $600 million in fees on the transactions that then netted them a $5 billion fine. So that's 9 times the cost of what they got in fees. Oh, and they had to give back the $600 million in fees. And so financial institutions see things like this that happen, which then if we have more of the criminal prosecutions, we have more examples for them to look at. Canadian financial institutions are doing what they can with the regulations that we have in place. We need more tools. We absolutely need more tools. We need more, we need information sharing to be addressed. Something that would help with that is a corporate registry. And that would help not only with the compliance costs, it helps law enforcement with their beginnings of their investigation for information that's hard to ascertain right at the beginning. It helps if the regulators would then recognize for the institutions that this information is usable, because there have been comments that we don't verify beneficial ownership information that's provided, but where are we supposed to go? We need more tools, and as I said emphatically, say that Canadian financial institutions aren't looking at this as window dressing.
So to be clear, financial institutions would be, I guess, on the record, for lack of a better phrase, on wanting to change the rules around beneficial ownership. I mean, certainly from a journalist perspective, and I'm sure from everyone else, finding out who the owner of a numbered company is in this country is next to impossible.
It is. And so financial institutions, you know, I can't speak for all of them. I can certainly speak for, well, I can't speak for BMO. I've said that at the beginning, as views of my own. But most financial institutions, if you're not going to provide, and so we need to now ascertain the beneficial ownership to 25%. And if you're a broker dealer, IROC actually requires it down to 10%. And if you're not going to provide that information, you may not get a bank account. So how are you going to pay your people? Like, how are you going to do payroll? How are you going to operationally manage your business? It's something that, in fact, FATF had mentioned in the mutual evaluation, and this goes back to shell companies, and it goes back to nominee directors and shareholders. We need to close that loop. So we have companies have the legal ability to be anonymous through some of these loopholes. And that's where, you know, Canada and the government and the legal system, we need that addressed. So banks need help. We've been finding, you know, who the beneficial owners are. If we had a place to go that the information was verified, that would actually help all of us.
Beverley, one of the questions from the audience asks, what role does Canada's lack of a foreign intelligence capacity play in our ability to prosecute foreign bribery? Do we depend too much on the investigative capacities of our other jurisdictions, for instance, the United States and the UK?
Gee, I wish I could answer that question. It's not something I've come across in preparing for this, but it might well be a factor. We know that some of our neighbor countries, the people who are in the top 4, for example, do have extensive offshore investigatory bodies. What Canada has, I don't know, but one doesn't hear very much about it. I think perhaps Drago would be in a better position to answer that, but we have federally our RCMP. Drago has said complimentary things about their efforts, but we do know that we are just not getting the number of prosecutions that we should.
Sorry,
Yeah, see, with the exception of the US, you know, there's no other country which would have, let's say, the network of foreign intelligence officers would be much bigger than, let's say, in Canada. So Canada is at the level of other countries. But as we heard today already, you know, there are other countries which are also with the same or even lower amount of resources are fighting foreign bribery much better than Canada does. Let's say if you just take a look, Israel is the last one ending in the best group of enforcers. Of course, you cannot compare economic, let's say, strength of both countries, even on the size, based on the size now. So this is, I would not say this is one of the most important reasons. What we are trying to do in group is we are trying to motivate all elements of the state to participate in let's say, identifying the cases which might be later on turning into foreign bribery cases. The diplomatic network, the foreign trade representatives, financial institutions, and so on, auditors. Of course, we don't expect them to be specialists in this area, but at least they have to be capable. And this is the concept which is already being, let's say, we are drawing this concept from the money laundering area, a concept which has been proven already that all those are professionals who have to know at least the basics of, let's say, if we speak about corruption, but corruption. They don't have to do the investigation themselves. What is needed, what we expect from them is simply to make a call or to send an email, and it will be picked up by professionals, the RCMP or any other a specialized institution. So I would not say this is the biggest problem. It is just showing that, let's say, the whole attitude of Canada towards those problems is not at the level of, for example, the United States. Or say it in other words, Canadian representatives, it looks so are not so sensitive towards those things, because I can hardly imagine why we are stuck with such low numbers, especially in comparison. If you would compare the how big the economies are, I would expect that, let's say, that in the biggest economies in the world, many more cases would happen.
Lida, I know you're also on the board of Transparency International, so I'm hoping this question straddles one of your portfolios. But someone has mentioned here that there are some financial advisors who've spoken at previous conferences, and I know that this issue is out there in the public domain, that the penalties for financial crime in Canada are simply too low to be any kind of meaningful deterrent, that they're seen as the cost of doing business. If you can get away with it, even better. If you're caught, no real harm done.
That's true. We haven't seen, this is part of our whole discussion that we've had so far. We have not seen significant penalties, significant convictions yet in Canada. So there isn't really a deterrent. And I'm going to flip this around a little bit. I wouldn't say that it's a deterrent for financial institutions, but in fact, it also attracts the illicit actors to the country. Mm-hmm. And if we don't have the tools and the mechanisms in order to stop them, then that becomes a problem. And for the most part, is there going to be within an institution potentially somebody who could let something go? Is it there potentially a control that's currently a human control that should be more of a technological control where things can slip through the cracks? Sure. You know, if you're looking at real time, financial institutions look at transactions one at a time. Illicit actors create this complex, tangled web of cross-border payments using different institutions and different channels and mechanisms for getting payments to go across the border. So is the penalty to the financial institutions, you know, around the world, penalties have been much greater. I just gave a massive example of last week's Goldman Sachs determination. Is that something that Canada should look at? Absolutely. I think also the criminal element needs to be brought into it a little bit harder. Around the world, executives are now being charged criminally by different global regulators. So again, are we playing a game of catch up? Is it that, you know, oftentimes when you look at some of these regulatory fines for what everybody has been doing, you're looking at, say, 5-7 years in the past. And if you spoke to that same financial institution the day the fine was announced, they've likely already remediated what the fine was for. But overall, I think we do need to have more examples, and we need to have stronger fines and criminal fines to be a greater deterrent for both the illicit actors and, you know, for any of the financial institutions. But actually, I'm going to stretch out and say it's more of the designated non-financial businesses and professions that we need to look at as far as compliance and deterrence.
We're all familiar with the phrase of snow washing, of trading on Canada's reputation as a good actor on the global stage, and that you can wash your money here, that once it comes through the banking system in Canada, it's seen as kind of a clean pass to move it anywhere else. Drago, I'm wondering, when we look at the penalties for breaking the law, whether it's around bribery, corruption, money laundering, the gamut, where does Canada sit in comparison to others? Do we penalize people in the same way that they might be penalized in the US or the UK, notwithstanding that there are more prosecutions there? When you are successfully prosecuted, is it worth it to do business here and risk being caught? Or is it, you know, are the penalties comparable?
Well, there are two problems which, let's say, which influence me when answering this question. The first one is that on the really limited number of cases, it is difficult to draw general, let's say, conclusions. And the second, our last report came out in 2013, and since then, hopefully, many things have changed. I would say so that I cannot say that the Canadian sanctions are too low, but what I can say for sure is they do not fall into the category which would be recognized in the group as, let's say, one of the most stringent ones. So this remains to be seen when we will do the regular check of Canada. Until then, we were just hoping, let's say, that getting more cases will also help us to realize and understand how sanctions are applied here. Of course, if Canada will go the same route as many other countries go, that Canada will use remediation agreements more and more, then of course it is difficult to draw in a line. But I can tell you that in the remediation agreements, the fines which have to be paid by the companies are, in principle, much higher than the fines which they are are applied following the trials. So, if Canadian system will start to use these remediation agreements more and more, I'm sure also the sums of money which will be involved will get much bigger.
Beverley, there was a question from one of the people listening on, though, with respect to the mediation agreements or deferred prosecution agreements. Does that prevent the public from getting a full understanding of what took place? Does it effectively shield the company from public scrutiny?
Well, I don't think it does necessarily. If you have the right legislation and the right prosecutorial service, there are systems. Many countries insist on the prosecutors making reports if they decide what on their decision to recommend a deferred prosecution agreement or else otherwise. And I don't believe that the practice in Canada, we just get a decision. But prosecutors here are not required to provide reasons for their decisions. I think if you had a recognized body, prosecutorial authority, and I'm going beyond my expertise here because I really think you need to have a thorough study of exactly what to do. But assuming you had a recognized prosecutorial body, I know there's an area in the Department of Justice that does this now, but it was out there in the open and they published reports and the prosecutors made written decisions about why they had decided to recommend a deferred prosecution agreement or why they had rejected it. And that was out there. Then I think you have a high level of transparency and it would become more acceptable to the public. But it is a concern. I understand that somebody who never reports or never has to account makes these decisions, and then we don't know what that company did or didn't do or whatever. And then I think there would be publication ideally down. You have a transparency agreement that becomes a matter of public record. There's the admission by the corporation of what went wrong. There's what they're going to do to fix up their culture. There's the fines. So I think that in other jurisdictions, these things are working, it seems to me, fairly well, and the public is satisfied that they are getting that it is that it can be in the public interest and it can be transparently run. On the other hand, there are critics of these deferred prosecution agreements, and they say, well, the companies will just swallow the cost, and it's not that they'll adjust, and it's not sufficient, that prosecutions still need to be vigorously performed. And I have a sense, my own sense is that you need both sides. You need a vigorous prosecutorial arm that is actually on those cases where a remediation agreement is rejected, prosecutes vigorously and efficiently. And then you should also probably have the possibility of these deferred prosecution in appropriate cases, and the whole thing should be transparent. And I think in that sense, we probably get the best of all worlds, and we get a fairly high level of enforcement. But I want to say those are just my preliminary impressions. And what I was struck with is in this area is that we really need to give it a lot of hard thought, and people who really know how these things work in other countries and need to come up with the answers to questions like the one you just posed, and see how we in Canada can get everything together so we can improve our performance.
On that note, Drago, I mean, Canada's not reinventing the wheel. We're not having to come up with something that other countries aren't themselves facing and dealing with. From where you're sitting, what is holding us back? Is it lack of political will? Is it Canadians at large not recognizing that this is a problem? You know, all of these things tend to be thought of as victimless crimes. We've all heard that phrase. Is it that the people don't understand the scale of the problem? Is it something else? What, from where you're sitting, seems to be standing in our way?
Well, may I just add a sentence or two to the previous question on this, the remediation agreements? Say what's going on in Canada is basically what happened in all countries which introduced those, let's say, legal way, with the exception of one or two. And we have to know that there are no international standards for those agreements. So what we're doing now in the group, we are developing those standards, and transparency required will be quite high. So we will be asking countries to publicize the conditions under which, let's say, the prosecutors can enter those agreements. And when the agreements will be sealed, they will also have to, the state will have to publish the conditions of the agreement, description of the case, the sanctions and everything. So we will be insisting on this transparency. And I have to say, when we had discussion on those future standards, we got quite, say, good support from Canada too. So it's not that Canada would be afraid of. Canada just, let's say, not trying to find the best ways to proceed. And hopefully they will also use the opportunity of which our new standards will give them. So on your question, it's, let's say, it's all of that. I will simply say that when we see the situation like we have it in Canada, where a country with a fairly developed democratic and legal system, with basically all legal parts in place, with institutions who can do the job, but obviously they're not doing the job, then we are basically saying that there is the lack of real will to do it. This is, let's say, speaking from the dealing with the flaws or the loopholes in the legislation, incentivizing the law enforcement agencies, giving them more resources, or simply pushing them to do more in this area, it simply means that somebody will have to do it. Legislation, it could be good, it could be bad, but legislation is always adopted by parliaments in which concrete members of parliament sit. And if they receive good proposals, most probably they will adopt good proposals. If they don't receive such proposals, we simply do not see legislation improve. I have to say, let's say that according to my experience in the last 7 years since I'm chairing this group, is that we see positive movements not when really big changes in the legislation happen. We see big movements when the attitude towards our problems changed, meaning when countries realize that international foreign bribery is a serious form of corruption, when they understand that fighting foreign bribery does not mean harming their economies, but helping them, assisting them, when they do understand that this is basically leveling the playing field for companies from their country too, then things changed. Sometimes it takes so much time, sometimes it happens almost during the night. I would say that in Canada, it's taking a lot of time now. So I really hope that one day things will move and accelerate quickly. And I see, let's say, I see the remediation agreements as one of the elements which can push things towards the right direction. But of course, it's not enough that we have good wishes sitting in Paris. Somebody in Canada will have to push.
Along those lines, someone giving an example of, I would argue, maybe the lack of commitment we have to this in Canada. Someone says, it's worth mentioning that out of curiosity, I tried to incorporate a shell company at the federal level. It took me 10 minutes, required no ID checks, and there was an option to be listed on the business registry in Ontario. Then I went to renew my library card in Toronto and they asked me for ID. And this is, this is not an extraordinary circumstance. We hear this a lot, whether it's through the lack of transparency around beneficial ownership. It's the exclusion of lawyers and legal entities to disclose who they're acting for, who owns the company, that we appear not to be taking this seriously and are sending a signal then to bad actors that this is a place to come, that no one's going to look very closely. And Lida, it's true that the banks take a lot of heat for this too, that they're saying at the one hand that they would like more tools, but are also happy to do the business if nobody's going to crack down on it. And I realize you can't answer for your employer directly, and that's fair, but how would you address that claim that the banking institutions themselves are not doing enough?
Well, first, I'd just like to say that I've never heard anyone say that they'll do business with somebody because the fine just is too small. And that's me personally saying that. I think that what we have to realize is the example that the participant just gave. Let's look at that for a second. So somebody can incorporate federally a company, and then it's up to the bank to be able to find out the beneficial ownership, to find out source of funds, to find out a myriad of information, which we do need in order to know who we're doing business with. And yet, if we had, like, what kind of partnership is that from the federal government, right? If they're not taking any onus to getting that information for us to be able to find it. So now the financial institutions have to be investigators. Otherwise, they will get fined. Or otherwise, worst case scenario, somebody could lose their banking license. So I think that what we really need is better partnership. And I don't think that banks want to just bank anybody. As I said before, nobody really wants illicit money flowing through their bank. But what we need the tools. And we need government and law enforcement and the legal system to provide the tools to do that. And when I say that, I go back to what I said earlier about shell companies and nominee directors and shareholders. That's not going to be popular idea with people who want to use those to hide wealth or move money around. But it's something that we need. We need the political will to just get it done, because we're taking too long. And that's just, we're inviting more and more illicit actors to use Canada as their place to launder the money.
Beverley, we've talked a lot about what would be needed additionally to what we have now to crack down on these things, but are we properly using the laws we already have?
Oh, that's a good question. It's a mystery to me in some respects why we haven't had more prosecutions. You heard the numbers from Drago over the years, I think 7 or 8, which is just inexplicable. I've mentioned the high mens rea. I've mentioned the fact that you have to establish a Canadian person in the institution. All this has to be proved beyond a reasonable doubt. We have very, very difficult to prove offenses, and that deters prosecution. You see it in other areas, in our hate crimes, for example. You have very few prosecutions, and people say, well, it's just because it's so hard to get a conviction. And of course, it costs a lot of money to do a prosecution. And if you're just going to fail at the end of it, the prosecutor looking at it, looking at the evidence they've been able to adduce, says, our chances here are 50-50. Should we go ahead? The answer might be no. And so I think one of the things we could do in Canada is really do an examination of our laws to see whether they are higher than necessary. And look at what countries like the United States, United Kingdom, and other countries, Israel, France, are doing. And how are their laws making it more possible or easier to get these prosecutions? So I think that's a big factor. And I don't know whether, I think the RCMP does a very good job, but I suspect that in countries like the United States, they're putting a lot more money, throwing a lot more money at this. Very dedicated people who know this area inside out, and who have resources, and human resources and financial resources and I don't know enough to say whether we have that or not, but I think we should ask that question. Have we got the right prosecutorial investigatory setup? I pose it as a question because I really don't know the answer. But if I were looking at this with what has been described as a desire for change, political will, that would be one of the questions I would ask.
Drago, I am curious because one of the laws that Canada most often turns to prosecute money laundering, in fact, is married in the act with terrorism financing. And I recall the RCMP some time ago, we're talking about, in the balance of their budget to prosecute those cases, there is reasonably that the public will, the public interest influences where it goes. And for a time, there was a feeling that, and certainly in TI, there was a feeling that the RCMP and other federal bodies were focusing on the terrorist financing part, paying less attention to the money laundering part, even though one might argue they're often linked. Is Canada sort of falling behind in terms of its legislative footprint on this? Do we need stronger laws that are better recognized around the world as existing here and that will be used?
Well, even in the international area, the money laundering and terrorism financing are basically mentioned each other closely. So there's no difference. I think the majority of the countries of the world now have laws not only against money laundering, but they say against money laundering, terrorism financing. Of course, it depends which part you pursue more. And it changes from year to year what is really important. So there are years when fighting terrorism is really the most important topic for all law enforcement agencies in the world. Then the next year comes when it's fighting corruption. Then the next year comes when it's money laundering or some other crime. So I would not say that this is a problem which is very specific for Canada. What is missing, I think, is what Beverley has mentioned. Basically, we are discussing, we say there's a problem because there's no enforcement, but we do not know what are the reasons, the roots of the problem. And of course, nothing will change in Canada if only, let's say, a group like us will be barking from Paris and tell Canada, you have to do that, you have to do that. But when questions started to rise in Canada itself, like we are doing today, then I just hope that somebody will listen to. And because it's obvious that Canada is not putting enough attention to the issue of corruption. It's seen on many levels. From the legislation point of view, let's say Beverley has mentioned some problems. Lida has mentioned the problem with transparency of beneficial ownership. Diana, you gave a perfect example, or one of our listeners gave it. The question of resources is always present. Somebody will simply have to sit down and to do something to understand why this is happening. And let us not forget, we are not talking about the newly developed country which doesn't know what it's doing. The institutions in Canada are very well developed, and I'm sure that they are aware of all the loopholes they have in their specific jurisdictions, legislative ones, institutional ones, or practical ones. And I'm also convinced that it would not be too difficult to get a list of the most burning problems, why we are not doing it better than today. And then just simply to start looking for solutions. But also to do that, you need what we call political will.
Lida, certainly from my perspective as a journalist, when we've done stories in the past around, the range of things, whether it's money laundering or tax evasion or so on, it can be difficult when we're trying to tell a story to make it feel like it lands, that people understand the connection between their world and what we're talking about. And often there's this real disconnect. People think of this as the games that rich people play, and that it actually doesn't affect them. But we see that it does, and it affects, the banking institutions and how they operate. And it affects, I think, for most people in a really tactile, real way, it affects their property values. If you live in an area like Vancouver, Toronto, Montreal, in areas where money has been parked in order to wash it or to leave it here for a while, it can affect those property values. But I'm wondering, is there a role for the banks, for financial institutions to play in making that connect for average Canadians? Because maybe that is what's required to get more inertia here on changing the laws, strengthening the laws, more prosecutions. It's making people feel like this is important to them.
Well, it's a very good question. And I think that the banks have a multi-pronged role to play. I think they have a role to play, certainly in Canada, and they do so through the Canadian Bankers Association and in working together. Whether they have, I think they can work in concert with the media in order to provide more information when it comes to personalizing what's going on. So you mentioned the Vancouver housing market. So between 2012 and 2017, there's an estimated $2 billion that flowed, illicit funds that flowed into the Vancouver housing market. Ask somebody in Vancouver, and this is pre-COVID craziness that's come up over the last 6 months of the buying that's gone on across the country. But ask somebody who's a first-time home buyer if they can afford a house. What's happened is if you've got this illicit money flowing into the real estate market, prices start to go up. And what better way than to have it parked into an asset that's also, not only have you cleaned your money, but now it's going to go up in value. I think if people understood more what the personal consequences were to the actions that are happening in, you mentioned earlier, victimless crimes, potentially, or crimes of the rich. I don't think they also understand that, if you're not paying corporate taxes, if a corporation's not paying corporate taxes, then it makes their income or their taxes more expensive. And then I'm going to just also flip this around, where people need to understand the consequences of these crimes. And I'm going to turn it on a topic we haven't actually touched upon, and it's not fully relevant to this, but counterfeit goods. If people think, you could buy the luxury purse or shoes, counterfeit item, and they think the only one who's being affected is the big conglomerate who's not going to make as much profit. But in reality, their money is going to organized crime in order to facilitate human trafficking and narcotics trafficking. Now, if people actually knew that that's where their money was going, would they then care enough to stop buying those counterfeit goods? Right? So I really think that the secret here, and I don't know how to implement it fully to get people to understand, but they really need to look, there needs to be a localization of impact for people to understand the personal consequences of all of these actions.
Beverley, you understand the power of words as well as anyone. You've written so many decisions. I'm sure I couldn't name them all or even know how many you've written. But it seems to me that maybe that is one of the parts of disconnect, is that we tend to use language around these discussions that disconnects from people. We talk about corporate corruption or bribery, money laundering, things that make it feel distant from average Canadians. If we were to talk about it in terms of organized crime or criminal behavior, might that change the way people see it?
Yeah, I'm a great believer in stories that have human participants, and if we could get more journalism, more books that bring these crimes home to the human level. So you see the exploited people, You see the people who just don't have a chance of buying a house, and you link that to these issues. And in that way, you can raise the consciousness and change the culture. I was told in preparing for this by someone who works a lot in this field, that a number of nations, third world nations, nations not as nearly as prosperous as Canada, nations once were where bribery was an accepted way of life, have now been changing their cultures around. And so it is possible, I believe, for countries to say, no, we don't want to be known as a place where you can launder your money, snow wash your money. We don't want to be known as a place where many of our resource companies, mining companies, et cetera, operating offshore by in complicity in corruption. We don't want our country to stand for that. And then also related to the individual level, the little girl who's trafficked and somehow through some criminal activity. That's the way I think we have to have an effort, I really do believe, to raise Canadian consciousness about how much this is costing and what it's doing to our brand.
And pulling on that theme, Drago, I wonder, I mean, I can imagine that there are Canadians who would hear that and say, well, absolutely, we would never stand for those things happening here. But I can hear the next part of the sentence from some people saying, but, you know, this is how business is done. This is how business is done in a place like Libya or another country in which there is no rule of law right now, where it's kind of mercenary activity. And if you want to get something done, well, you know, you call it a bribe, you gentle Canadians, but this is the way it's actually done out here in the international business world. How do you counter that kind of rationalization?
Well, you see, when I was young police investigator, I simply could not understand why companies which are functioning perfectly legal and highly ethical back home, as soon as they crossed the border, they started to let's say, to engage in many dubious businesses. So back home, they were sticking to very high standards. As soon as they left the country, they went somewhere else. They have forgotten the standards. And this is still happening today, to the lesser extent, but still. And listening to them is what you said is basically what they're telling us. You know, we couldn't do the job otherwise. We could not sign the contract if we would not pay somebody or if we would not facilitate something. So it is on a short term, of course, they will maybe sign the contract. But what happened when they sign a corrupt contract is very simple. No, it is not the quality of their services or the products which matters anymore. It is the volume of the bribe. It doesn't matter how they call it, but it's the volume of the bribe. So next year, the next company will come, and the next company will offer $5 or $10 more than they paid last year. This company will lose the job. So it's not about, let's say, gaining one contract. We have to work all together to explain to the CEOs, the management boards, that when entering countries which you mentioned, or let's say, which are famous by not sticking too much to the law, they're basically not destroying only the economies of that country, but they are also destroying their own company, because it might happen that one day they will be left without any further contracts, not because of the law enforcement activities, but because somebody will come who has more money to spend on bribes, and they will lose the job. And this is why we are saying, let's say, in the OECD, our final goal is to level the playing field for all companies. We hear quite often now that, let's say, there's especially one country from which companies are traveling around the world and are gaining all the biggest contracts simply because they are not sticking to any international anti-corruption standards. We are trying to get this company to the group. They don't want to yet, but we hear serious, let's say, accusations from other countries that basically their companies are losing many contracts because that country is using corruption as standard way of doing business. But things are changing slowly, and it will fire back. And this will happen to all companies, especially if this is not, let's say, the general practice of that country. And I would say, maybe the problem with Canada is that let's say, your decision makers, they really do not understand how bad corruption is and what consequences corruption causes. Not only destroying, let's say, people's lives, which they can see on TV, that if the police officer doesn't accept the bribe, his family will not have anything to eat. This is one part of it. But what we're talking here is we are talking about high-level corruption, which is destroying not one life, we're destroying company with several thousands of lives. And this will cause not only reputational damage to Canada, this will cause also all sorts of economic consequences, which in the end might really be a very bad thing for Canada. So I would say, if maybe what Canada needs, and I really hope it will not happen, underline, I really hope it will not happen, but maybe Canada needs a big, let's say, big case, which will be really tragic, and maybe then somebody will start to think. But once again, I really hope it will not happen, because I'm convinced that Canada can accelerate it even without it.
It's an interesting point, though, and someone raised the question that we've been talking so far about corruption involving Canadians or Canadian companies, but largely corruption happens abroad. And how is Canada behaving? Yeah. And they raised the question, how are we performing? And Lida, I'd put this question to you. How are we performing at managing or cracking down on corruption that happens within Canada? Quebec is an example where the Charbonneau inquiry did make it public to people. People were able to watch it, follow it, begin to understand the labyrinth that takes place with many of these things. And it did seem to crack down on it, at least brought it to the public's attention. Are we doing a good job across the rest of the country in doing that?
It's a very good question. How many Canadians know about the BC casino money laundering report and Peter Sherman's report that followed? Maybe they knew about it at the moment that it happened, but that they follow anything with the commission afterward. How about the WE scandal with the WE charity? People, they pay attention for the moment. Unfortunately, over the last 9 months, we've had a major distraction with COVID, where people's attention spans are smaller because everything goes back to COVID, and rightly so. We're in a pandemic. Drago, I hope you're right that we don't have a big major case, but sometimes big major cases are what catch the attention. But how big is big? Was SNC big enough? Is the WE charity scandal big enough? I'm not sure.
We're almost out of time, so I'm actually just going to go to each of you just for a couple of final thoughts. Beverley, I'll start with you.
Well, I think that we really need to start thinking about the basic question: how can we do better? It's a complicated area, and I don't think anyone has a magic bullet. But there seem to be a number of areas where we can ask questions. Have we got our laws right? Have we got our prosecution right? Have we got the balance between prosecution and deferred prosecution right? And on this last question, internally, how are we doing internally as well as internationally? I think it's a big area, and we really need to ask some questions in a very concerted way, get some experts in place. We had the BC Casino Money Laundering Commission, and it showed us that in one particular area, you can come up with quite a few recommendations and quite a bit of knowledge about what's happening. More broadly, I think for Canada, we need to look at what we should be doing now. We should have our governments focusing attention on it.
Lida?
I absolutely agree with that. I also think that when we get everybody in a room, it has to be more collaborative, and we have to have everybody. So we need to have government, we need to have the regulated entities, we need to have law enforcement, we need to come up with a holistic solution. We also need to make sure that we do this with pace. We're very slow right now. As we've said, Drago has made that clear, I have, and so has Beverley. We really need to move a little bit faster. COVID has shown us that through the use of technology, more people are online, more people are working from home. Technology makes all of this easier, not just for the criminals, but on the flip side, it helps solve things, and it provides transparency. If I take this now to the global view and my participation with the B20, the B20 this year is also looking at information and communication technologies as part of the solution for many transparency issues, corporate registries being one of them, public procurement information being another one. So I think we have to start thinking outside the box as far as solutions go. And I think technology is one area that we can do that. I think we need to be more assertive and participatory on the global stage. We just had the very first ever anti-corruption ministers meeting for the G20 happened last week. They came out with a Riyadh initiative, which is for enhancing international anti-corruption law enforcement cooperation. So hopefully that's going to go somewhere. But we really need to look at partnership and collaboration on a global scale. But we can only do that, we can only be leaders if we first solve these problems at home and we don't try and make the solution as complex as the problem.
And Drago, last words to you.
Well, I think Beverley and Lida have said everything, but I will be very short. So Canada deserves to be one of the leading countries in fighting corruption in the world. You know, United States are known by their, let's say, almost, I will not say perfect, very good enforcement. The United Kingdom, let's say on the other side, since 2016 or 14, they are being, let's say, very active in this area. And why I'm mentioning US and UK, because I think we can compare Canada with those two countries for many different reasons. And we don't hear Canada at all. So I think things will have to move here. I don't know if I have used this comparison already today, but if I did, I will do it again. You see, when I'm looking at Canada, it looks that if we understand fighting corruption as a very nice car, then in Canada this car has all the elements it needs, but it still drives very, very slow. So we'll have to push it, we'll have to accelerate it. And maybe not only the push from the government, well, somebody will have to push the government to start engaging more. I'm not saying that government is not engaging, but for sure more could be done. We have an example of a country where the private sector has pushed strongly, and is also one of the G7 countries, and a new law has been adopted. And since then, this law has completely changed the character of anti-corruption efforts of that country, and the country is now, let's say, increasing in our ranks. So, well, we don't have official ranks, but it's doing better and better. So if the civil society, if the public sector will push, and as far as I understand, there's a constant pressure from outside, then for sure this car will start moving faster. And this is all what we need. You know, it's not just enough to put elements together. The engine has to start too.
Thank you very much. A perfect metaphor to close on. Beverley, McLachlin, Lida, Preyma, Drago, Kos, thank you all for joining us and for your thoughts on this. And I'll edit. I think we're just perfectly on time, and throw it back over to James and Susan.
Great. Thank you very much, Diana, for an excellent first day of TI Canada's Week of Dialogue. I wasn't at the beginning of this. Our chair and president, Susan Cote-Freeman, introduced. For those who don't know me, my name is James Cohen. I'm the executive director of TI Canada. I was moderating a bit of the chat. I'd like to thank our panelists and everybody who joined today for the past hour and a half to kick off this week. We are back tomorrow and every day this week at 12 Eastern We'll, as Susan said at the beginning, we'll be diving into this question further tomorrow. We have a panel on how are our institutions performing in Canada. We heard a lot about it today, and we'll be looking into it a lot more tomorrow. And before everybody goes, I would just like to say also a thank you to our supporters, which includes our Platinum supporter, Export Development Canada, our Gold supporters, Banque Nationale, Blake's, BLG, Deloitte, Denton, Siemens, Sky Power Global, and our Silver supporters, ACFO, Elisa, Kinross Gold, KPMG Canada, Vidoc Group, and Thales. We heard a lot of talk about there's more investigations to do in Canada, there's more work to do, and TI Canada definitely has the spirit to do this, but we also need the financial support, as we heard a lot about resources. If you'd like to support TI Canada, you can become a TI Canada member. You can become a supporter like our Platinum, Gold, and Silver supporters we have below, or you can make a direct donation to TI Canada if you just go to our website, transparencycanada.ca. And we'll look forward to seeing everybody again tomorrow and through the week for this great conversation. Thank you all, and have a great rest of your day.